Very warm welcome and thank you for joining this panel discussion on meeting changing needs in the context of pro bono advice projects and looking at different models of service. I'm delighted to chair this panel. I'm Diane Sechi. I'm Senior Pro Bono Lawyer at Simmons and Simmons. I also work part-time at South West London Law Centre, where I carry out a practice of housing, community care and welfare benefits at the Upper Tribunal. I'm delighted to have the expertise of the panel members. That's Matt Hunt, who is Head of Not-for-Profits and Secondary Specialisation at LawWorks, Tony Martin, the Head of Clinics at BPP University, who runs Pro Bono Clinic in Leeds, London and Manchester, and Sarah Michael, who manages the UK Pro Bono practice for the international law firm Sidley Austin. Before hearing from our panel members, just a very brief introduction by way of context. The UK has a long history of lawyers carrying out pro bono work, and many lawyers regard pro bono work as an integral part of being a member of the legal profession. The breadth of pro bono work carried out by volunteers is very wide and includes work undertaken by solicitors, barristers and law students. There are many different models of delivering pro bono assistance, and this includes, for instance, assisting individuals, charities, community groups and other voluntary organisations. For individuals, this assistance could be, by way of example, legal advice clinics offering one-off advice, clinic settings dealing with more in-depth work, and increasingly remote clinic settings offering advice remotely. And also there are pro bono programs offering more tailored and structured assistance covering specific areas of law. These are often referred to as secondary specialisation clinics. And there are also the brokering services which have existed for many years, and this includes LawWorks and advocates. They provide a vital service of connecting individuals and voluntary organisations with lawyers willing to offer pro bono advice and assistance. However, whatever the model or the delivery mode, pro bono services, like all other services, have had to adapt to environmental and societal change. One such change, for example, was a spike in demand for pro bono assistance following the implementation of the Legal Aid, Sentencing and Punishment of Offenders Act, which removed many areas of social welfare law from the scope of public funding. It is fully accepted that to enable access to justice for all, there should be a fully accessible legal aid system, and this is undeniable. However, the longevity and success of pro bono services demonstrates that it plays an important role. So being able to harness the power of pro bono in changing times calls for a sustainable pro bono model, robust enough yet sufficiently flexible to adapt to change. Some elements of such a model which come to mind, and I'm sure the panellists have other ideas, could include, for instance, having trusted partnership arrangements with frontline agencies and other stakeholders, having a solid referral network, having an agile pro bono coordinator, having the ability to replace volunteers, being able to ensure ongoing training, adequate supervision, monitoring, evaluation and reporting. These latter elements are really important when thinking about using pro bono for more strategic or policy aims. So in these unusual times, how can we ensure that pro bono support can adapt and maintain and continue to play an important role in the delivery of advice and assistance? To explore these issues and share their own experiences, I'll now turn to the panel members. And possibly, Matt, if I invite you to go first. Thank you.
Sure, thanks very much, Diane. And thank you for everybody else for coming from your sitting rooms, wherever you've come from. Apologies for my lockdown beard as well. I'm sure we're all kind of used to this way of meeting and chatting, but I got quite excited about ironing a shirt this morning, and it's nice to see that people are kind of smartly dressed. So I'm going to talk about secondary specialisation and how LawWorks does it. But first, following on from what Diane said, I'd like to explain what secondary specialisation is. And it essentially involves in-depth casework and is named for the fact that it involves volunteers providing pro bono work, but also gaining experience in a second area of law. For example, corporate finance lawyer providing advice to or representation for an individual in relation to welfare benefits. So you can see that it's slightly different from the traditional clinic model of a one-off piece of advice, but also that you may already be doing it or something similar under another name. And I'm going to talk about the way LawWorks does it, which is slightly different given the way LawWorks is structured from other organisations. And with the rest of the panel, hope that we'll show you a variety of models that you can use to meet the changing. Jane Basham just said they call it legal casework. Great. So we have 3 secondary specialisation projects which operate in welfare benefits, employment law, specifically unpaid wages, and community care law. And each was set up in response to a specific and changed need for legal services. So Diane mentioned earlier LASPO, and our unpaid wages project, which helps people challenge wage theft, is the term, by employers, was set up in response to a citizens' advice report in 2016 about the growing trend in wage theft, which was partially reversed by the Unison Supreme Court decision, but the trend remains, unfortunately. And for each project, it's structured that LawWorks engages the client, given that we're using volunteers who don't practice this area of law. So one of our specialist in-house solicitors has carriage of the matter, and each case falls under our insurance, but volunteers conduct the bulk of the work. They have training from an external provider, and they use our suite of template documents, legal guides, and practical guides. And cases are referred to us from other organisations, and we have a member of staff whose role includes matching volunteers with clients. So our specialist in-house solicitor is, well, the idea is that most of their work is just using their specialism, and the volunteer solicitors are there able to provide work quite in depth in another area of law, but they have the comfort that there's an expert there taking charge, providing advice, reading through all documents before they're submitted, and that ultimately it falls under our insurance. So it's a great way of properly utilising the expertise that we have in-house and the enthusiasm and transferable expertise from other areas of law in volunteers. I mentioned that we have 3 projects: welfare benefits, unpaid wages, and community care law, but they really fit into 2 strands. So the welfare benefits and employment law projects focus on an area of law, and they involve tribunal work, so they're procedural and they have a geographical focus. What that means is before lockdown, they existed only in London, and they begin with the volunteers conducting a client interview with our solicitor present. They draft the pleadings, they negotiate with third parties, and then they either negotiate a settlement or they conduct tribunal advocacy. And in that way, the procedure in the area of law is the same for each case, and they can gain experience quite quickly. And I'll only briefly mention this because Sarah Michael on the panel will talk about it in detail later. But this is because of the similarity between cases. Law firms can get quite a lot of experience in these areas of law, and Sidley Austin has got to the stage where they can take on clients themselves in certain circumstances. The third project that we have, the community care project, doesn't focus on an area of law. It focuses on a beneficiary type, so it's a slightly different model. We run it jointly with a charity based in Bristol called Together for Short Lives, you might have heard of, and the goal of the project is to provide legal advice to the families of children with life-limiting illnesses. So it essentially involves holding local authorities to account in respect of statutory duties towards these children. And what this means is that the area of law, and therefore things like timelines and strategy, has more variance between cases. All that means is that we match solicitors and clients in a slightly different way because cases can vary a little more. That project works remotely, and it worked remotely before lockdown because Together for Short Lives are based in Bristol. We are referred cases from a range of organisations across England and Wales. Our in-house solicitor also works in Bristol. And there's no need for in-person client meetings or advocacy. So actually it was a good model to adapt to current circumstances. But turning to the area of law, it's quite important for secondary specialisation models that the relevant law is discrete enough that it's appropriate for volunteers to undertake. So while the goal is to provide in-depth casework, there are sort of practical limitations on the depth of advice that a non-employment lawyer can give in employment law cases, notwithstanding the fact that we have an expert overseeing what's going on. And part of what LawWorks does is that we're a volunteering organisation, so we're mindful of the volunteering experience, but we also do have a duty to our clients. So the areas of law, unpaid wages, are quite discrete. Community care is actually fairly discrete, and the welfare benefits project we run only conducts advocacy in respect of certain benefits. So the volunteer lawyers do become sort of specialists and experts, but not in the whole breadth of an area of law. And that has that's there for practical reasons, but it also means we can really target the help. So there's sort of benefits to that necessity. So that's the LawWorks model in a nutshell. And also one of the sort of two unique elements, which is that volunteers come from other organisations. The other panel members have volunteers provided by their organisations, essentially. All that means is that we have included in our model relationships with other organisations interested in the same work, which is actually really beneficial for us because it means when we want to adapt it, we already have a network of organisations that we can speak to about making those adaptations. Similarly, we don't take on clients who approach us directly. We are referred clients by third-party organisations. We have referral forms and we use them to assess whether cases have been referred appropriately. Again, that's useful because from a volunteering point of view, it means that a case has been sort of reviewed internally and packaged and is ready to go the moment they are matched to the client. But it also means that we have relationships with other organisations that we do similar work, and we're not operating in a vacuum, essentially. We can become more aware of trends, we can stay up to date with what's going on in the sector and discuss new ways of working with them. With an eye on the time goes really quickly. I want to briefly talk about COVID-19 and lockdown, briefly for time reasons, as I said, but also because we all hope, I definitely hope, the lockdown is temporary. And the models that we have for secondary specialisation have worked for a number of years leading up to lockdown and will work in the same or a similar way whenever it ends. And I don't really want to just talk about what we've adapted to coronavirus without setting out, as I have, what we've done. So during lockdown, the impacts on the mechanics of the models is actually fairly minor. Reacting to everybody working remotely is fairly straightforward because it really involves moving face-to-face work to telephone or video, and one of the three projects already runs remotely anyway. The impact is really significant, though, in terms of how it's affected clients and how there have been sort of policy reactions. So, for example, in the unpaid wages project, we've seen quite a significant drop in the number of claims for unpaid wages, and this is why it's useful to work with other organisations. The feedback from individuals is that people who are furloughed or currently employed and therefore in a position to make a claim feel that their employment is fairly tenuous. The people who are targeted by wage theft tend to be fairly vulnerable, and at the moment their position is, I am getting some money, I will challenge whether that amount is correct when furlough ends. So the sector is anticipating and preparing for a massive rise in cases in a month when furlough sort of winds down a little. And similar with the welfare benefits project, the focus of the DWP has been on universal credit for obvious reasons. So tribunal hearings are not being, well, haven't been listed for a number of months, although there are bizarrely some cases that are still out there that people have sat on for a couple of months. But as far as taking the model online, as far as that goes, that's actually been quite straightforward. And I can only see sort of 4 people at the top of the Zoom, so I won't scroll through all the pages of the 118 participants. I think my colleague Richard Picathly is here, so if he is, sorry for just name dropping you, but we are working on a manual for how to set up secondary specialisation projects, which we intend to obviously be a public resource, and the goal is that you can download or save the environment and read on your screen, read this massive document on how to set up a secondary specialisation project, give us a call and we can help you do something similar. So you don't need to just have taken lots of notes during out the panel. I think that's my time up. Is that correct, Claire? Am I up?
I will hand over to Diane. She is chairing you.
Thank you.
Thanks, Diane.
Thank you, Diane.
Okay.
Thank you, Matt.
It's difficult when you can't unmute yourself at the first instance, but anyway, thanks ever so much, Matt. There was quite a lot there. I mean, it seems as if LawWorks have got some kind of really solid foundations in the, especially in the secondary specialisation projects. If I just may, and I don't want to kind of incur on other people's question time, are you or is LawWorks anticipating setting up any new secondary specialisation clinic for any new emerging trends that are coming out because of the pandemic? So, or are you just anticipating moving forward with the 3 areas that you currently practice?
Both, because they're linked. I don't want to name any particular area of law because obviously the plans are tied to funding applications, so I don't want to get anyone's hopes up. But yeah, the answer is essentially yes. There are new areas of law that are being impacted, and there are existing areas of law that are being impacted in new ways, and we are absolutely looking at how we can expand. But yeah, I don't think it would be appropriate to name them.
No, not.
Yeah.
But it just seems as if LawWorks do have that agile model that's able to adapt to change, which is great. Okay, I'd like to now move on to Tony Martin. Tony?
Hello, yeah. Hopefully you can hear me. I was going to talk about tribunals and our work in tribunals, but I want to firstly just say something about context. I work in a university setting, so on the one hand we're trying to meet unmet legal need for those who can't afford to employ solicitors or barristers to represent them, and on the other hand we're trying to give students experience of the law in a way that is controlled and supported. So that's the context in which we work. And across BPP we're working quite a few different tribunals, and I'm going to concentrate on one tribunal, the first tier residential property tribunal in London, which is a tribunal of the property chamber. But I want to make some general observations about tribunals first. And firstly, just to touch on the whole situation of COVID-19. Tribunals at the moment that are operating are mostly dealing with paper applications. Some of them are doing some telephone hearings, and most are prioritising for obvious reasons, or perhaps only dealing with, for obvious reasons, urgent cases. But tribunals are beginning to reopen in line with the courts, and certainly there's a backlog of cases in the tribunals. The first tier tribunal, the property chamber, has a backlog, they tell us, to April of cases to issue, and they're accepting cases for issue at the moment by email. So come autumn, there's going to be a large number of cases and a large number of people who are struggling with poverty, perhaps for the first time, who are going to need legal advice. At the moment, we're providing that advice online and by telephone, and we continue to run, including our drop-in, but we're not doing any work in the tribunal itself because the hearings aren't taking place that we can be involved in. Some tribunals have UK-wide jurisdiction, others only have jurisdiction in England. Apologies to those of you who are in Wales, are less familiar with the situation there. But leaving aside upper tribunals, there are over 40 tribunals in England, and not all are relevant to pro bono, but a great many are. And I guess what we offer in the tribunal is what in a commercial firm would be called unbundled services. And that's important because what we don't do is offer a full service. What we do is offer a number of discrete services. But for example, we offer advice by letter, we offer drafting, statements of case, Scott schedules, witness statements. We offer bundles, putting together bundles for people, which people really struggle with, negotiation, mediation support, and representation. And in the residential property tribunal, about 30% of leaseholders or tenants are represented, and about 70% of landlords. So that's the imbalance that you have there. And one advantage, I think, of tribunals, if we leave aside the complexity of working in the immigration tribunal, is that there are no issues of rights of audience. Anyone can represent in a tribunal. So there's no particular qualification required, and that means for us, students can represent in the tribunal. And in the vast majority of tribunals, legal aid has never been available. And regardless of how things have developed, tribunals were created with litigants in person in mind. And it seems to me, therefore, that they're a natural space for pro bono representation. And we're not the only organisation that works pro bono basis in tribunals, and I'm sure many other pro bono organisations would agree. But the stats that James shared earlier today suggest that only about 15% of clinics offer representation. And I think if you're going to start offering representation, tribunals are probably the ideal starting place for that. And working in a single tribunal also brings some advantages. It allows the ability of building a relationship both with sympathetic members of staff and the judiciary. And we get information, which is, whilst it's not confidential information, it's not easy to come by, provided to us by the administrative staff. And senior judges are very welcoming, and they've come in and given talks to our students and provided training to our students. And we have a trainee solicitor that I'll talk about if I have time. And they've allowed our trainee to sit in on cases as well at the tribunal. And so they're very generous with their time, and that's very useful. Another factor about tribunals is that they're governed by their own set of rules, not by the civil procedure rules. And when I first started at BPP, we had a senior judge come in and she gave a talk, and she made the point to our students that often solicitors and barristers will attend the tribunal clutching their white book and quoting the CPR, only to be told that the CPR doesn't apply. And she made the point, and it's a very valid point, that if you know the rules of the tribunal, then you can use those to your advantage and your client's advantage over much more experienced opponents. So the advantage of working in a tribunal, I think, can be summarised as a limited range of cases and a limited area of law, a discrete set of procedural rules, a client group both in need of advice and representation, the ability for volunteers to undertake advocacy in a controlled way, a limited cost risk in most tribunals, and a good working relationship in there. But one other factor is about strategic approaches to cases. And many tribunal cases will have an impact wider than the single client that you're representing. So in the residential property tribunal, for example, cases have the ability to impact upon all the leaseholders in a block, and sometimes wider still. And I'm going to focus on one example, and I'll put the link to one of the nice things about working in the first tier residential property tribunal is every decision is published. So I'm going to pop the link in the chat box to the decision of the tribunal, which is there. Talk a little bit about this this case, which took place earlier this academic year. And Wandsworth Council had applied to the tribunal for a determination for their right to install sprinklers, and the leaseholders therefore liability under the terms of their lease to pay for that, pursuant to section 27 subsection 3 of the Landlord and Tenant Act 1985. You don't need to worry about the law particularly, but the impact is that this affected around about 100 tower blocks and about 2,500 leaseholders, so a significant number of people. And the reality is that because the council had no immediate plans to install this, those properties would have been unsellable for the foreseeable future. And one group of leaseholders, who were themselves landlords, instructed solicitors who have made a strikeout application, and other groups of leaseholders have made their own strikeout application. And we were instructed by one group and they made their strike application not very well, if we're honest about it. And we agreed that we would only represent them rather than just note-taking or supporting them if there were points to take that the solicitors who were representing another group of leaseholders had not identified, legal points that we could make, and we did identify those. And we abused the rules slightly in the tribunal, which you can get away with a bit in the tribunal, by using the reply to the council's reply to their strikeout application in order to make the points that we wanted to make in the strikeout application, the points we would have made had we been instructed originally. And because of the impact of this case, it was held in Wandsworth Town Hall, not in the tribunal, because a large number of people were involved in it and a large number of people wanted to attend. And the council, very worried by this stage about their whole scheme, had instructed a QC and a junior, and naturally the solicitors therefore instructed a QC and a junior, and our client was represented by our trainee solicitor, Hannah Lennox, who's here somewhere on in this conference, supported by 2 students, and she had to make her application before a large audience, and naturally enough, the application succeeded, and the council's application was struck out successfully. And the impact of that is felt by a wide number of people. And I just, if I've got time, wanted to touch on that about the question of a trainee as well. Just that by employing a trainee, we're able to do a lot more in our pro bono work than we would otherwise be able to do. There's some real benefits to that. Basically, we took an administrative post. We had an administrative post before, and we took the money for that administrative post and used it to employ a trainee. And we provide a very hands-on training contract. I would say certainly a better contract than many firms provide. So I don't think there's any worry about meeting the necessary outcomes. And if you're old like me, you're probably thinking of training contracts of having 3 discrete seats and one being non-contentious and one being contentious. But actually training outcomes are not quite like that anymore. You have to meet certain requirements of the SRA. But of course, we're moving into a situation with qualifying work experience. So even those requirements are going to be diluted. And we certainly can meet all of the requirements that are required by the SRA in relation to a training contract. So I think the benefits of training are very widespread. Now, I appreciate not everyone is in a position. Some clinics are only volunteer only, but one solution to that might be to ask a city firm to second a trainee, maybe for a period of time, to do a seat in your clinic, for example. That might provide for that expertise as well. So I'm mindful of time, so I'm going to shut up and hand back to Diane.
That's great. Thank you, Tony. Diane, do you want to come back?
Right. Thanks, Tony. That sounds like fantastic work. And I like the strategic angle of it. Just a couple of thoughts actually from that. First of all, where does BPP get their clients from?
We get our clients from LawWorks website. We get our clients from our own website. The tribunal, in the information the tribunal send out when people issue, they're told about us. When people phone up seeking advice about issuing, they're told about us, and we run a drop-in at the tribunal as well. And like all commercial firms out there, we get repeat business and a lot of word of mouth as well.
Okay. And the other thing that struck me about the program you're running is it's quite resource intensive. I mean, BPP have obviously got they've got you, they're lucky to have you, and they've probably got a team of people who are guiding these students. How transferable do you think that model is, let's just say, to a city firm where capacity may be an issue and they may not have that infrastructure of resources to be able to kind of run a tailored kind of tribunal service? Do you think it's easily transferable?
I think it is. I mean, it's basically me that runs that project, and I supervise those students, and we have a trainee, and she works on the project for half of her training contract. She's now working on family cases. I think it is. I think also, the expertise. I came, my background, as you know, Diane, we used to work together, was a social welfare lawyer and a housing lawyer in a law centre, and I'd only done one service charge case before I came to BPP, but you soon learn. and it's exciting to do a new area of law yourself, and you've seen learn and that. And basically, I suppose my approach with students is, look, can they do a better job than the litigant in person? And if the answer to that is no, then I'm slightly worried about the student, if I'm honest. And so in most cases, it's yes. And some litigants in person want to run their own case, and that's absolutely fine, in which case we'll provide them administrative support, we'll send a student along to take notes for them, to take that burden away from them. But most really struggle. And they really struggle with not just representation, but with things like, how do you draft a statement of case? When a tribunal tells you, file a statement of case, how do you do that if you never drafted a statement of case before? Now, some of our students have never drafted a statement of case before, but the advantage they've got is they've got access to precedents and materials, and they've got access to supervision. So they can draft a statement of case, have it critiqued, redraft it, et cetera, et cetera.
Brilliant. Thanks so much, Tony. I'm sure there's going to be a lot more questions, but I'm conscious of time. So for the last panelist, Sarah Michael, I'm going to hand over to you.
Thanks, Diane. So I was asked to speak today about sort of secondary specialisation, and to be honest, I wasn't entirely sure how I felt about the term secondary specialisation when I first heard it. But however, what I think is actually interesting about the term is the idea of encouraging pro bono volunteers to develop an additional specialisation in an area of law that's outside of their usual expertise through their access to justice work. It can enable the lawyers to actually work on cases where there is the most need to the maximum impact. I think the idea comes from that in any practice area, whether it's your primary area or secondary area, the more and more familiar you become with an area of law, the less supervision you require. That obviously sounds quite obvious, but which is why if you encourage our pro bono lawyers to adopt a secondary area of interest, then they can take multiple cases in the same area, which enable us essentially to help more people through our pro bono work. You know, for example, I work in a city firm. If a city lawyer has 50 hours that they can spend on pro bono with their capacity within the year, if one case is going to take 50 hours, then they can only take on one case and help one person. But actually, if they've done so many that it takes them 10 hours, then that's 5 cases that they can take on in that year and 5 people that they can help through their pro bono work. I think obviously it's really important, and Matt mentioned this as Diane touched on as well, that secondary specialisation projects are reliant on training in an appropriate discrete area of law, and supervision and support by experts. And this is absolutely fundamental. And in some cases, like Diane's at Simmons, that can happen from within the same firm or the same organisation, but a lot of the time it will involve training and supervision by an external expert. And those external experts are fundamental to ensure the quality of the work, but they would only be able to take on a finite number of cases themselves. And if a volunteer is working on them in a completely new area of law for the first time, they will take an awful lot more intensive supervision, and probably not a huge amount of time is saved in them doing the case themselves. Whereas if they have had that expertise, then they would require less supervision, essentially, the more and more they are able to build up experience themselves in that area of law. And some models of pro bono secondary specialisation can restrict that sort of fluid development of expertise and require basically the same level of supervision, irrespective of whether it's someone's first case or someone's 6th case. So developing a model that can allow for that sort of fluid approach, depending on someone's experience, similar than you would get in private practice in a legal aid firm, where someone would require less supervision the more experience they gained, is beneficial to meeting more need, as well as developing the volunteer lawyers' experience themselves, and also allowing firms to look at sort of the bigger picture and work on sort of side projects that deal with some of the more policy angles and things like that. So as Matt touched on, we've been working with LawWorks to change the way we work on secondary specialisation projects with them to allow for that approach. And we have also been doing this when we're looking at other secondary specialisation projects to see how that could develop, as well as actually encouraging our lawyers to embrace that concept of finding an area, because actually they will get more from their pro bono time and their pro bono volunteering experience. And I just wanted to very briefly touch upon also collaboration in the areas, in the context of secondary specialisation, because actually working collaboratively is so important. That's collaboration between any type of organisation, and actually a lot of these projects, you know, they involve collaboration across multiple sectors, advice sector, maybe a city law firm, maybe legal aid law firm, a clinic, and actually that's so fundamental for running a successful project. But also it's important to collaborate not just on the project, but with other organisations that deal with different secondary specialisations or primary specialisations. Because actually when we're looking at the changing need that is out there at the moment, whether that's due to COVID-19 or whether that's due to the legal aid cuts, that actually, if we can work collaboratively, it allows us better to assess where the gaps in that need are, and actually where pro bono support would be appropriate in those cases. And I think that's just a fundamental element when we're actually looking at the changing need, that actually collaboration is so important. I'll pass back to Diane. That was my, I think I'm under my time, in fact. So.
Great, thanks a lot, Sarah. Yeah, collaboration is indeed really, really important. I was wondering, have you had any experience because of the pandemic of the stresses that have obviously incurred at the front line? Because lots of frontline agencies, I know there's a pot of funding gone in, but those stresses are going to continue. And have you experienced any difficulties or indeed any other opportunities in your own line of pro bono work due to those stresses wrought on the frontline services? Have you been able to adapt to that, or have you responded to that in any way?
Yeah, absolutely. I mean, I think in terms of secondary specialisation, it's a slightly different question to actually the work that we've been doing with those direct agencies. And actually, that is where corporate law firm support can be really beneficial, because actually we can use our everyday expertise to really make a difference to organisations that are really struggling. And I know you mentioned the funding, and that is an absolutely important part of this. And pro bono is so reliant on the important, absolutely fundamentally important work that the advice sector does, that it would not survive without it. So it is a really important part of a pro bono lawyer's role and city firms' roles in actually supporting the advice sector through these really challenging times.